My name is Leonardo, and I'd like to thank you all for being here. Thank the audience, and also Connor and Bruna Castro. Connor will be our speaker today, and Bruna our debater. But before we start with the presentation, I would like just to give you some notes regarding UI, who is the organizing institution behind this event today. So UI, Understanding Artificial Intelligence, is a multidisciplinary group from the Institute of Advanced Studies at the University of São Paulo that researches and curates knowledge to promote inclusive, diverse, and ethical AI. We have 6 core streams of research, which are ethics, governance, public sector, health, society and culture, and regulation. This specific event is hosted by the Regulation Group and is part of a series of events that we are carrying out throughout the year on regulatory discussions concerning AI. This event is also made in partnership with the IEE from Ribeirão Preto, the C4AI group, which is the Center for Artificial Intelligence at the University of São Paulo, and the Center for Advanced Legal Studies and Innovation from the Law Faculty of the University of São Paulo at Ribeirão Preto. The idea today is to have a 40 minutes presentation from Connor, our speaker, followed by some questions to be posed by Bruna and maybe I, and maybe we can look to the chat and see if we have also questions there. So just to introduce Connor. Connor is the European Public Policy Lead at the Ada Lovelace Institute. He has a master's degree in conflict studies and human rights at the University of Utrecht and a bachelor's degree in history and politics at Newcastle University. Connor is currently based in Brussels and is responsible for discussions concerning the governance and regulation of AI in Europe. On the other hand, we have Bruna as well, who is SADOT's AI governance specialist, which is headquartered in Helsinki. And she, alongside her work as an AI governance specialist, is pursuing her PhD in Law and Technology at the Tampere University in Finland, with a research focus on AI accountability and remedies for AI harms. So without further ado, I'd like to leave the floor open to Connor and his presentation. Thank you very much.
Thank you so much, Leonardo, and to Bruna as well. It's really exciting to share this panel with you. I shall just present my slide deck. Yes, there it is, perfect. And yeah, this is my first time speaking to a Brazilian audience, so super excited to get this opportunity. Thank you for that. So yeah, as was mentioned, I'm Connor. I'm the European Public Policy Lead at the Ada Lovelace Institute. And what I would like to talk about today, I'll give a brief introduction to the institute where I work. Then most of the presentation will focus on the EU AI Act, sort of a landmark bill worldwide regulating AI, the first of its kind. Then I will do a brief sort of overview of AI liability in Europe as it currently stands. I will also then briefly touch on AI regulation in the UK, which is much more on the lighter touch side, so that will be a shorter part of the presentation. And then finally, yeah, very excited to open up for questions and conversation with the other panelists. So yeah, before I go into the content, I wanted to briefly introduce the institute where I work, the Ada Lovelace Institute. Maybe it's worth pointing out who Ada Lovelace actually is to start with. She was quite an icon in the UK. She is considered one of the first computer scientists and was like a female in tech. So for that reason, she's very iconic in the UK. She worked with Charles Babbage on the concept for a computer in the 1800s already. They were writing letters about the concept for a computer. So yeah, in the UK, she's an icon, and this is why the institute is named after her. Yeah, we were set up in 2018. Most of our researchers are based in London, but we also have a Brussels office. So that's where I'm based, myself and 2 others. But in London, we have 25 people. And yeah, we're quite proud to say that we're an independent research institute. So we really take this lens of how AI and data impact people in society. And yeah, we have we think a lot about where our funding comes from, so in order to maintain our independence. from government or private sector. So yeah, we think this gives us some unique angles on this question that should involve all of us across society. So yeah, like I said, I will go into spend most of the time talking about the AI Act, but I can maybe give you a brief overview of our other work in case it's interesting. So we look a lot in the context of regulation and governance around what we call accountability mechanisms. So maybe some of you are familiar with a lot of the methods that are out there. So audits of AI systems. Also, in recent times, there's been a big focus on evaluations, model evaluations of foundation models or general purpose AI models. So we really try and focus on how accountability is assigned in AI, and what tools we use to do this, and do they actually work? That's a question that we always try and ask. Do the tools that we're using to assign accountability do their job? And sometimes they don't. And then, the final bullet point, and this is the main focus of my work, is indeed considering how all of this accountability should be reflected in standards, law, and policy. So why we decided to sort of set up an office in Brussels. We thought that, of course, with the AI Act that's coming, landmark piece of legislation, we really thought that we were well placed to support some of that process. Like I said, we have a big research team in London, and the questions that we've been focusing on, they were very relevant also for EU policymakers. Some of that work that I mentioned before on accountability mechanisms has been something that policymakers have found useful. Also, similarly, a lot of comparative governance work has been, I think, helpful to policymakers. We've looked at, for example, how life sciences are regulated in the USA to understand is there lessons that we can learn from that for the regulation of AI. That's one example. We also focus a lot on how the AI value chain should be governed. So what a developer can do, what a deployer can do. More and more, we're actually looking at what maybe a host layer of the value chain could do. So like a Hugging Face. And that's some of the unique angles we try and bring to the EU conversation. So to set the scene a little bit before doing a deep dive on the AI Act, I wanted to briefly mention some other pieces of regulation that are on the EU's agenda in terms of digital files. So we also have going on here, they're now complete, but the Digital Services Act and the Digital Markets Act. So these are really looking at the regulation of online platforms and online marketplaces, respectively. We also have a Data Act and a Data Governance Act. So these look at sharing of data in the private sector and also in the public sector. And it focuses on concepts such as like interoperability and thinking a lot around infrastructure behind sort of AI and data. So this could be cloud contracts and switching, how easy it is to switch cloud providers, for example, is something that the EU has been looking at a great deal. And then the third bullet point here, the AI Act and AI liability. So that's the ones where I focus most of my time, and therefore I will spend most time on those during this presentation. So to get to the main part of the talk, the EU AI Act. So a bit of background first. It was proposed in April 2021, and it was the process of, I think it was 2 years already before it was proposed. There was a high-level expert group on AI set up in the EU. So this was a lot of academics and other types of practitioners informing the European Commission about how they could design this landmark legislation. How it was scoped as a product safety legislation, which was, I guess, quite a big choice. It wasn't designed as like a principles-based legislation or one just looking at fundamental rights protections, and it wasn't rights-based to begin with, maybe like GDPR. So they really considered AI a product, and that has scoped a lot of the approach off the back of that. But the interesting thing that they did there, normally EU product safety legislation would look at health and safety, of course. But the interesting innovation that they made for the AI Act was that they introduced also protection for fundamental rights with the AI Act. So this has been a very interesting tension throughout the process in terms of regulating as a product, but also regulating to protect fundamental rights. Based on this product safety approach, they focused on what they call a risk-based approach, and focused very heavily, at least at the start of the process, on the intended use of an AI system when it's deployed. Based on the intended use that was given by the provider or the deployer, that would shape what level of risk the Act categorizes the product as. So originally, this meant that there was, as you can see, hopefully you can see with the visualization, there was sort of 3 tiers, or in this pyramid that you can see. It might be a little bit hard to make out the writing, but at the top of this pyramid in the red is basically some prohibited practices. So some AI systems that were completely banned in the EU. And I can expand a bit on what those would be in the next slides. Below that, and this was the main focus of a lot of energy and attention during the legislative process, the high-risk use cases. And I'll explain what those were. But yeah, that's kind of the heart of the regulation, and that's expected to capture 5 to 15% of the EU market could be categorized as high risk. Below that, in the green, you have low-risk AI uses. So they're not subject to very stringent requirements. It's mostly transparency mechanisms. For example, labeling AI-generated output would be one example of what low-risk obligations might look like. So not too burdensome. And then on the right-hand side, what you can see, this was an interesting development throughout the process. So they introduced a sort of 4th risk category called systemic risk. And the reason that this was introduced was looking at what we call general purpose AI models. So this is like a GPT-4, which ChatGPT is built on top of. So the EU thought, okay, these would fall through the gap a little bit because they don't have a high risk intended use in the product safety scoping, but they clearly could pose substantial significant risk, especially if they act as a sort of new infrastructural layer of the digital market. So they introduced language for general purpose AI models and language for systemic risk. And on the later slides, I will explain in more detail what that means. So yeah, to go through each of those sections and give you a bit of some meat on the bones of what that means. The systems that were prohibited in the EU include things like subliminal manipulation that causes harm. So that's something that the EU is completely banned. Similarly, some tools used for social scoring in terms of accessing public services and things like this, they've also been completely banned. And then the final one here is remote biometric identification. So this was the most contentious part of the AI Act. And this was basically like facial recognition and other types of identification used by police, by law enforcement. So there's real-time biometric identification and also post biometric identification. So they have language to say that real-time remote biometric identification, it's quite a mouthful, that is banned, but there are very wide exemptions for law enforcement to use this. So it could be if they say that they're searching for a child that's been abducted or a terrorist, they have some exemptions to use this, this type of AI system. So yeah, on paper there's a ban, but in practice, I think it doesn't completely ban the use. But it still sets, I guess, globally quite a landmark or quite a high bar that has not been there before in terms of curtailing the use of some of those technologies. Then yeah, moving from the prohibited systems to the high risk, you can see on the right hand side here the types of AI systems that have been classified as high risk. So a lot of these focus on public sector use. So you can see law enforcement in there. You can see access to essential public services, things like welfare. Anything around the judiciary is also covered. migration, and yeah, education, healthcare, these types of things, critical infrastructure, of course. So this is how they scoped it. And yeah, I think this in theory should be a living piece of legislation. So they would envision updating this list with time. Maybe some will be deprioritized. New types of use cases will be introduced to the list. So it should really be, this is sort of setting a floor that could be built upon. In theory, it will be a living piece of legislation. So those are the types of systems that are classified as high risk. Then to explain a little bit what that means, if your system is classified as high risk, what would that mean for someone using this, a business selling or deploying this type of AI? So yeah, I would say in 2 words what it will look like in practice for businesses. It's really sort of documentation and due diligence, really. Some people from industry have said this is very burdensome, what they have to do here. At least at our institute, we would somewhat disagree, because a lot of this is all done by, as it says on the slide deck, internal compliance, self-assessment. So that is a lighter form of accountability or checks than what you would have in, for example, life sciences, when you would always have third parties involved doing the conformity assessment. Here, it's mostly just internal procedure. So in that sense, the big focus will be on solid documentation and being able to share that if needed with the regulator, but they won't have to do that ex ante before going to market. So yeah, what that would mean in practice, they have to put in processes for risk management, data governance. These are 2 of the really key ones, and they had quite a lot of attention during the process. But putting in place solid data governance and documentation requirements. Another key component I would highlight is human oversight. So always making sure there's a human in the loop for high-risk AI decisions. It's something that we think makes a lot of sense. It wasn't challenged very much during the process. I would also highlight here robustness, accuracy, and cybersecurity. That was one that was challenged quite a lot during the negotiations. It's a very to the point that I made at the start around it's a product safety bill, but it touches on fundamental rights. I think questions like accuracy and acceptable levels of accuracy for an AI system in a high-risk area are very much fundamental rights questions rather than just product questions. So this is something that's been definitely a challenge during the process. They haven't found the answer yet, and this is what they will use, what they call standard setting bodies to operationalize. But yeah, deeming an acceptable level of accuracy, that's something that seems very important for fundamental rights protections. Maybe on that topic, I will highlight one more, which is the final bullet point on fundamental rights impact assessments. So this will be an obligation, and I put it in italics because it's only for the public sector. Private sector deployers do not have to do this. But if you use a high-risk AI system in the public sector, you have to also, before deploying it, do a fundamental rights impact assessment. So this would really, we think it can be good to change mentalities and cultures within the public sector, at least, where they would have to really sit down and think through the repercussions for people in society when they choose to use an AI system. So that could be in, access to public services using AI for this, like a chatbot, for example, provided by a government agency. They would have to think around if there's any fundamental rights implications. And I think this is helpful for changing the culture of the tech industry, which can be a bit move fast and break things. So yeah, moving to the next category, we have prohibited, high risk, then turning to these sort of general purpose AI models. So I mentioned that one example of that would be GPT-4 by OpenAI. And this was, again, another very contentious part of the negotiations. In the end, it became a very technical discussion. So as you can see on the classification point here, they decided to classify two tiers of general purpose AI models. So there's general purpose AI models broadly construed. So and then there's the ones that pose systemic risks. And for now, they're classifying the ones that pose systemic risks using a compute threshold. So based on how much compute was used to train the model. So they've gone with a threshold of 10 to the power of 25 flops. This is one lower than what they use in the United States. So the US executive order has 10 to the power of 26 flops. The EU's went one lower. And yeah, we at our institute, we don't support, we think compute thresholds are a good temporary proxy for what poses systemic risk, but very quickly this will not be a reliable way to measure which models might pose the most risk, because there's a lot of efficiency gains with algorithmic advancement, more efficiency from compute. So this threshold will definitely change a lot. And a lot of the risk, of course, will also come from how and where an AI system is deployed, not just from the size of the training run. But we still think it's helpful because it can at least give regulators an idea that a very powerful model is coming, like a GPT-4 or GPT-5 level model. And the interesting thing about the threshold, one more thing I'll point out, is that with 10 to the 25 flops, that means that the EU is at least regulating 3 to 4 general purpose AI models. So the latest Gemini model from Google DeepMind would be captured by this. OpenAI's GPT-4 or any future models that they release would be captured by this. Probably one from Anthropic, one from Inflection AI. So that's worth noting because compared to the US executive order, 10 to the power of 26 flops, they are not currently capturing any models that are on the market. So I think that's an interesting differentiation, or to try and give some picture behind the numbers there. Yeah, in terms of what the obligations would look like, most general purpose AI models, like smaller models, they just have to do basically transparency obligations. So a lot of it's focused on what type of documentation they should do, and sharing this information downstream with sort of application builders who build on top of their model. There's also a big focus on copyright, which another contentious topic, but they should have to publish a summary of copyrighted data that was used to train the general purpose AI model. And yeah, it remains to be seen how detailed that summary will have to be. But it's an interesting, again, I think for setting some sort of global standard, I think it's good that that's in there. Yeah, and then maybe turning to the general purpose AI models with systemic risk, they would have to do some procedures like evaluating the model, so really testing it against the set of risks that the AI Act identifies. A lot of this is focused on like chemical and bio risk, nuclear risk, for example, like sort of quite extreme risks. So they have to do model evaluations to understand if those risks are present in the model. They will also have to have a procedure for dealing with serious incidents, for reporting this to governments, and yeah, very strong cybersecurity focus. So it kind of aligns with what a lot of the AI labs already do or say that they do, but it seems good to make this legally enforceable, at least under the AI Act, and to give governments some ability to access that information, because right now they don't have much insight into the workings of these models. So it seems helpful that that's at least set in legislation now. Yeah, another very contentious element of the Act was how to address open source AI. So I won't go through every part of it in detail, but yeah, I think basically the main thing to note is that the ambition of the EU was to give a lot of freedom for people who make their AI systems available under a free and open source license, which is quite important because there's some companies that have said they're open sourcing their AI models. For example, Meta would say this with Llama, but true open source advocates would say this is not actually open source, how they license that model. So for real open source as the EU would maybe think about it, there is an exemption from the obligations of the AI Act. Then you might, so that's for AI systems. For general purpose AI models, there are still some transparency obligations, again, looking at copyright, but not very burdensome. Then I think, interestingly, there is no exemption for general purpose AI models once they hit that threshold of 10 to the power of 25 flops. They would still have to do the same obligations of the Act, regardless of how they're releasing the model, whether it's a proprietary model, whether it's an open source model. But that also seems quite fair to us, given that a training run like this would cost tens of millions of dollars. So yeah, it seems fair that they should also have to do compliance. If you can train a model to that scale, even if you intend to open source it, it might make sense to also do some of the obligations of the Act. So yeah, getting to the end of the AI Act stuff, but maybe briefly in terms of how they're going to govern and regulate the technology. An interesting thing to note is that they set up a new AI office in the EU. And this is quite different to how they've regulated, for example, the GDPR or the data protection regulation in the EU. So with that, the enforcement comes from decentralized regulators across all the EU member states. But the new thing that they've done with regulating AI is that they set up a centralized AI office. So there they will hire, I think, 100 people to really focus on the regulation of particularly these general purpose AI models that pose systemic risk. That would be the main focus of the AI office. But they will also help to coordinate cross-border investigations. And they will also be a sort of a central point where experts, for example, what they're calling a scientific panel, will be able to interact with the regulator. They also set up a multi-stakeholder advisory forum, which is something that we very much support as a route for civil society, academics, other experts to have some say in the governance of AI, in theory, if it's set up as we would like to see it be set up. So yeah, I think that's the main thing to note on governance, that there will be a centralized AI office. Yeah, in terms of how to assess AI systems and AI models, one interesting thing to note is that they're leaning very heavily into regulatory sandboxes. So there would be a sandbox set up in every EU member state. And the aim of these sandboxes is to basically have a sort of controlled environment where they're aiming this mostly for SMEs and startups, or small and medium enterprises and startups. They're trying to provide them a space where they can test their AI system and get input on if they are compliant with the AI Act before it goes to market. So if this is done well, it can be quite a nice mechanism in terms of it allows the smaller players to understand if they don't have a big legal team, for example, they can go to a sandbox and they can ask experts there if they are complying with the AI Act before they put it in the market. And then you also get this useful thing where, in theory, the regulators can learn as well through this interaction. So they get to see some of these AI systems before they're putting them out in the world, and that allows regulators to upskill and learn at the same time. So if it's done well, again, that's something that we think we're quite excited about. And yeah, maybe briefly, there's going to be sandboxes, and there will also be evaluations. So this is what the UK AI Safety Institute does, for example. There's also a US AI Safety Institute that's been set up, and now the EU has an AI office, and they will all do evaluations of the models. Yeah, I think that's the main thing to note there. So yeah, in terms of what this might mean for the rest of the world, we do think that there will be a Brussels effect from the AI Act. So it's what we've seen with the GDPR that I mentioned earlier, the data protection regulation. You do see some jurisdictions sort of follow the EU's lead and set similar laws, not the exact same, but sometimes at least inspired by what the EU did. So you see sort of legal effects globally, or what you see is companies who they basically build an AI system or an AI model for the EU market, but they use it across the world. So you can maybe see the same AI model that was deployed in the EU being made available on the market in Brazil, for example. Sometimes it's just easier for the company to do this than to build two different models or systems. So yeah, that should happen. Maybe not, it's unclear to what level. Like, this is what the second bullet point is hinting at in terms of forking development. So what we would see is more likely to be a Brussels effect for these very expensive general purpose AI models that we mentioned, because to train a different AI model for every market would be very expensive because it can be millions each time. So what we might expect to see there is the builders of these very large general purpose AI models, maybe they will already be thinking around, okay, is this going to be compliant with EU law when they start training and developing the model? So in that sense, you might see the same model being deployed across markets. But if you have a narrow AI system with a very specific use case that's looking at, credit worthiness, or it's for use in healthcare, when jurisdictions have very different levels of standards and regulation, maybe that's when you won't see a Brussels effect, as a very simple intuition that we might have at this stage. So, okay, the first bullet point I've just noticed is outdated, so that has already happened. So it has indeed now been rubber stamped. And what we see here, I think the main thing to note here is the application period. So the rules for the prohibited AI systems, they will already kick in within 6 months. So from April plus 6 months, those rules should start to apply. So you won't be able to use, for example, social scoring systems in the EU within 6 months. Not that I think it's really happening so much now, but still good to have that legal enforcement. Then general purpose AI rules, they kick in within 12 months. So you're looking at maybe April next year. High risk use cases, they have 24 months before the obligations kick in. So that gives companies, a bit more time to prepare. And then finally, after 36 months, you have other high risk uses. So this is ones that are already regulated heavily in other EU legislation. So for example, medical devices, they have 36 months to get ready for this. Okay, so that wraps up the AI Act part. That was the main chunk of the presentation. I will now briefly touch on how liability is being addressed in the EU. So there's basically two main pieces of legislation to note here. There's the Product Liability Directive and the AI Liability Directive. The Product Liability Directive is now complete. So that was being negotiated until from 2022 to 2023. So that was updating existing liability rules in the EU for products to make them applicable to software and to make them applicable to AI systems, which wasn't the case before. The original was drafted, I think, in 1985 or something. So they weren't covering, they weren't thinking about software as a product then. So that's been updated. So that means now in the EU market that there's strict liability for material damages caused by software or an AI system. So I think that's an interesting thing to note, that it's strict liability. So you don't need to prove fault if you're harmed by the AI system. And if the damages are material, then you, in theory, should have a right to redress or right to claim damages. That contrasts a little bit with the AI Liability Directive. So they decided that AI might pose a sort of unique challenge for liability, given a bunch of things, like, for example, the opaqueness of AI systems, like the sort of black box that we often hear. That means that it can be very hard to build a case or to understand what goes wrong with an AI system. So they've tried to focus a lot of energy there more on transparency and being able to access information when an AI system causes harm. So you have this sort of parallel process. If there is material harm caused by an AI system, you should be able to get strict liability under the Product Liability Directive. But then the interesting thing is you might also have coverage for immaterial damages, so wide-scale bias and discrimination, for example, under the AI liability directive. So if that happens, there might be some legal avenue to get damages, and that would focus on not strict liability but fault-based. So that would mean that you could get access to the information, you could build a case, you could bring that to the courts and say, okay, I can prove the fault of the provider of the AI system, and I should be liable for damages. So that's an interesting one. That is still in negotiation. That will keep being negotiated, I guess, until next year, because it's quite a hard one, because it touches on, sort of legal jurisdiction across EU member states. And the question of immaterial damages is quite a tricky one. It's very important for AI. Maybe we'll talk about it with the panel, but it's a really hard one to square in a legal system. But yeah, the final bullet there is the burden of proof. So we at our institute find it very problematic that the burden of proof for showing fault under the AI liability directive is on the harmed person primarily. So they would be the one who would have to build a case to prove fault. And we think, given the challenges and the unique profile of AI, that can be very difficult for ordinary citizens or even lawyers working on their behalf. So those are the types of things that our institute will be working on this year, trying to think about if this can be improved and how. And yeah, I hope that gives like a sort of bird's eye view of how the EU is thinking about liability. Now, in the last, I see I've got a handful of minutes left, but I'll talk about how the UK is approaching AI regulation, and it will be much shorter because they are doing a lot less than the EU, basically. So the UK has basically published a white paper on AI. They've done a consultation on AI. They, of course, set up the AI Safety Institute, which I mentioned earlier, to do sort of testing of models, general purpose AI models, which is something that we definitely support. We're glad to see that it's well resourced. But we really think that what's missing is actual legislative footing for AI protections. The UK does not have that right now. And we hope in the next months there'll be some way that they can start to work on this. So yeah, the approach they've taken so far is what they're calling pro-innovation. And it's very focused on current sectoral regulators. So in theory, regulators across the UK can enforce action against AI systems, but based on where the AI system is being deployed. So there's not a sort of horizontal regulation of AI like what the EU is setting out. It's very much focused on principles. So these are based on the principles published by the OECD. So they are similar to some of the principles that underpin the EU AI Act, but they just don't have strong legal enforceability at the minute. And yeah, the final bullet point is they're doing a lot on horizon scanning. So they have a central risk function. They also have what I mentioned, the AI Safety Institute. And these are all really focused, like how they frame it in sort of understanding the technology rather than sort of regulating it yet. They think, I feel like regulation will have to come, but they're really using this period to understand before regulating is how they frame it. So yeah, that's sort of their general approach. Then there are other things that are happening in the UK that might be worth just flagging. So there is the Data Protection and Digital Information Bill, the DPDI bill. So there they are updating the UK's version of the GDPR, of the General Data Protection Regulation, in our opinion, for the worse, to weaken some of the protections there. It's not something I'm engaging heavily on, but UK colleagues are. They did also host the Global AI Safety Summit last year. So we do think that was an important milestone for sure to start having this global conversation around, the scale of the challenge. And we do think the scale of the challenge is really unprecedented. So we were glad that the UK did this. And finally, this AI Safety Institute that I've mentioned a few times, they have done a very good job of getting experts from, for example, people have left Google, DeepMind, and OpenAI to join this sort of government initiative. taking pay cuts to do so. So yeah, we think it's quite exciting what they've been able to build there in terms of expertise. Yeah, very briefly, I think I've kind of hinted at it, but we really think domestic regulation is needed in the UK, and they've been leaning too much on voluntary commitments from AI labs. So we think that would not suffice as a meaningful form of accountability. And we hope next year there'll be an election this year in the UK, and we hope next year or in the next mandate, some of that stuff can be addressed. So just to quickly conclude, yeah, I think there's some things that we can learn from the AI Act process for other jurisdictions, at least that can be directionally helpful. I think the first one is to think about the whole AI value chain. So this can be the developer, this can be the deployer, it can also be the host layer in the middle. It's a very complex value chain, basically. And we've done a lot of research, and we feel that the risk from AI can arise at any part of that value chain. So I think having rules that set obligations for all the actors where it makes sense to mitigate the risk in the value chain is the best approach. And I think other jurisdictions will start will start with that in mind. And that's different from the EU, who the initial focus as a product meant that they focus only on the downstream deployer. And that means that you let some of the, for example, the GPT-4 type system models off the hook. A second learning or a second consideration for other jurisdictions is, indeed, do you have self-assessment done by the AI providers, or do you have third parties checking some of this, like in other high-risk sectors? So yeah, we think that you should have third-party checks. We think it's a good way for governments to learn and to upskill. But the EU hasn't quite taken that route. They are getting insights in other ways. For example, I mentioned these model valuations. The UK is also getting that with the Safety Institute. But yeah, we think it's something that other jurisdictions should think about. We also think, I'll be a bit quicker now, thinking about the ecosystem to support the regulator is very important. So other sectors lean a lot on third-party auditors. In the AI context, there's need for sort of red teamers. And we really need to give people incentives to do this work. So there could be a whole ecosystem to support regulation, but we need governments, I think, to also incentivize that somehow. We think anything around transparency was something that was not contentious during the AI Act negotiations. Anything to get more information to the public on training sets, data training sets, and also then on the output side, making transparent to end users and affected persons that they're interacting with the AI systems. All this whole bucket of transparency measures were widely supported, and we think that they should be non-controversial in other jurisdictions. Standards, yeah, standards is a massive topic by itself, so I won't go deep on that. But basically, there is a challenge around setting regulation to say what the state of the art or what best practices are for AI when we're in such a fast-moving and nascent space. It's quite hard to clearly define what global standards should be, for example, on risk management or robustness. It's very hard to say what should be an adequate level of those things. And that's been a real challenge, and will continue to be a challenge, I think. I don't think it'll ever be a solved problem. It's something we have to just continue iterating on. I think, yeah, for AI, post-market monitoring is very important. Like, having one check before you go to market doesn't feel adequate. AI systems can change and learn throughout the life cycle. When they're deployed in new contexts, they can interact with users in different ways. So it really feels important to also have like flagging mechanisms and incident monitoring and lots of things throughout the post-deployment phase. Third point is around enforcement. So under the AI Act, there is the ability to fine up to 6%, but most fine 6% of annual turnover if someone infringes the AI Act. But most fines are set at 3% for high-risk AI systems and general-purpose AI systems. So I think that's a really interesting question around, is this strong enough to change massive corporations and their behavior? I hope that it would be, but some of them might, given the rate of growth of some AI companies, some of them might, be willing to be exposed to some of that risk when the fines are, in my opinion, quite on the low side. But other ways to change corporate behavior can be considered, like, for example, blocking market access for very extreme infringements. And then the final point is future-proofing. So this really needs to be a piece of legislation that is updatable. I think it's the only way we can grapple with AI and the scale of the challenge. So already we're seeing a new paradigm emerging, which is sort of AI agents, or basically AI systems where you can give them a prompt with text, but they can go and take an action on the internet for you, like to book a flight or design a website. So we're really now looking at what accountability looks like when AI agents come in. Is it sort of human-generated objectives or machine-generated objectives? That poses a big challenge for accountability and liability. Similarly, around GPT marketplaces, which we're seeing with OpenAI, they provide a GPT marketplace. So it's sort of like a new platform. So there's also like a digital markets gatekeeper question that could arise. So we really need to be paying attention to how the legislation can be updated. I think it's going to be a constant work in progress, let's say. So I'm sorry for going a bit over my time. Thank you for listening.
No worries, Connor. It was really amazing. Thank you. It was very insightful. And we only can thank you for this, this overview of the EU regulatory landscape, this legal and institutional dialogue regarding AI governance, which is always very important for us in Brazil and for our legal discussions that are currently going on in Brazil. So without further comments, I would like to leave the floor open for Bruna to pose some questions. We also have some questions from the chat, and we can now start some dialogues and discussions.
Yes. Thank you, Leonardo. Thanks, Connor, for digesting such a complex piece of legislation. I think it was amazing the way you structured and your focus and the way you approached your presentation. So I'm really thankful for that. And I have some questions, and I really liked that you touched on some of the points that I'm also very interested myself, and I think those are some of the biggest challenges that we have so far. So I think maybe I'll start focusing on the supply chain question. I think that is, I see that you also like that topic, and as you rightly talked about that. So how do you see the challenge of the so-called shared responsibility, or the allocation of distributed responsibility among the different actors? Because we all know that those actors in the supply chain, they have different powers, they have different their outputs and their decision making, they have different consequences shaping the models and the outcomes and so on. So it's not in any means equal distribution of impact and equal distribution of power. So what we call very unbalanced dynamics in the supply chain, right? So that has been also at the core of my own research. And what I also would love to hear from you is if you have a thought, or in your work at the Institute, if you have come across the support from, for instance, the business and human rights discipline. So we know that the UNGPs, they have been out there for a decade now, and they have a pretty solid framework for corporate responsibility for human rights impact. So in the way that we understand linkage, connection to harms and so on. So have you thought about that in your work, made this connection with AI governance and business corporate social responsibility, and how do you see that interplay between the two to address the question of how to allocate responsibility? Thank you.
Yeah, thank you so much, Britta. I think your brain and your research focus is going in very similar directions to mine and the Institute. Yeah, I can take the first part of the question. So I think, yeah, allocating responsibility is one of the biggest challenges right now, given the complexity of the value chain, which I mentioned. I think there are some unique features that make it really hard. So let's, for example, take like a GPT-4. It's a general purpose technology, and this is something that we heard a lot during the negotiations. They say it's a general purpose technology, so you can't say it's high risk. But you know, for sure, doctors or for sure lawyers are using this tool in their everyday work environment. So it's not inherently a high risk system, but it can be used for high risk uses. And I think the interesting thing about this is it's general purpose, but there is still some level of gatekeeping or control by the person who makes the general purpose technology available. So if you make it available via an API access, like what OpenAI does, then they still have a lot of control. Like they have all the access to the data. They have the ability to set the guardrails. So this is something that makes it very challenging. In most product safety legislation, it would make complete sense for all the responsibility to lie with the person who deploys it in a context. And it's true, that's where most of the harm will arise. But when you go about thinking about who was responsible for mitigating that harm or who should be responsible, you will often see that the person who deployed it would not have full control to have mitigated that. Some of that will live further up the value chain. So there's that. It's kind of that thing of access and how the systems and models are made available, and behind API walls, for example, is one example where this poses a challenge. I think there's another sort of market angle that we've been thinking a lot about, and that's if you think about the AI value chain, the oligopolies and the big monopolies live at the top of the value chain. And this is different from, for example, what we see in the automotive sector, where the oligopolies live at the end of the value chain. And what that means in like the automotive, they have a lot of power with contracts to set certain standards for the people giving them components. And that's not something that will see naturally with the AI value chain. So that what we would be concerned about would be the SMEs and the startups who buy from the general purpose AI model provider. They don't have a lot of power to compel high standards. And the flip side of that is that the oligopoly would have a lot of power to put responsibility and liability via contracts downstream. So that's where we think if governments don't assign the accountability across the value chain, the market effects are they're not ideal. So there's like a dual function there in terms of like who can actually mitigate the risk, and then like some incentives for doing it in terms of the market. So yeah, I guess that's kind of the first part of your question, and then to the second one, like around human rights and the corporate social responsibility work that's been ongoing. That's something that we find at times frustrating in the sense that I think in the AI sector, people like to reinvent the wheel and start from scratch. And there's corporate social responsibility. We also think like general risk management practice. Like there's really good lessons to be learned from, I mentioned automotive, aviation, cybersecurity, but AI practitioners like to start from scratch. And yeah, I think that's something that we try and like always highlight. It's the same thing with human rights impact assessments, algorithmic impact assessments. All those tools exist, but they're not always being leveraged. But one positive point around that is that more and more venture capitalists are coming. So the people who will fund these AI companies, and more of them are coming and asking us around how to assess responsible AI practices when they're allocating money. So I do think some of this historic like CSR culture is starting to come through, and I feel excited that that's happening. But yeah, also love to hear either of your thoughts, because it seems like, Bruno, you have thoughts on this.
Yes, thanks so much. Yeah, I fully agree with you, and yeah, that's my research. So I'm trying to build from the UNGP's framework to inform AI accountability and AI governance. So yeah, doing that in my PhD. But Leo, should I continue with the next question?
Yeah, you can continue with the next question. Then I have one, and maybe we can bring some questions from the chat.
All right. Yes. So the next one is not in any way easier than the previous one, but again, I noticed that we have similar backgrounds from human rights law. So I am really interested in my dissertation in the liability directive as well, and exactly as you said, we have this challenge between material harms and harms to rights, right? So this has been a problem forever. We know that as human rights lawyers and academics, but it's super interesting that with the AI liability directive, we have this possibility, right? But what really troubles me is how could we structure the remedy and the redress in terms of private enforcement of human rights when we talk about collective harms. So moving away from the idea of an individual, seeking the court of law and making its case about human rights violation, but really bringing to the table the new elements of AI harm. So scale, ubiquity of AI being used in any and every aspects of life. So how can we tackle that to improve redress and remedy, and to bring that really effective means of redress in the times of AI harms? So any thoughts?
Yeah, another very easy question. No, this is like something that we've been talking about this at least internally at the Institute for a long time, trying to understand what's possible within the confines of EU law. What would it look like in practice, which is kind of to your question. I mean, yeah, at least for the EU context, we're coming up against some challenges that, like for with an EU directive, I guess you have to consider what the level of protection is already in EU member states, and then that sort of curtails the level of, like, we would have actually liked to see a regulation rather than a directive. But I know, for example, Germany doesn't offer immaterial damage coverage, and then I think if a big EU member state like this doesn't offer immaterial damage coverage, then it's hard to get this set in stone as a regulation across the whole market. So that for us is a shame, I guess. So I think the level of immaterial damage coverage will depend on what already exists in each member state. But then, yeah, I guess what accessing that looks like is hard. Like, I do think the ability to bring collective action seems essential. I do think the AI liability directive, as it was originally scoped, would enable that. We're also looking at hooks from other sectors. So we're now looking at systemic risk in the financial sector, for example, and we're trying to see, is there a way that these pervasive harms to many people at once due to one systemic failure or one wrong decision, how liability can be is assigned in that sector. So we're trying to do this thing, this comparative governance, learning from past precedent. We're at the very early stages of that, but we're looking at that. I'm kind of glad that the AI Act introduces this language of systemic risk, which I mentioned in the presentation, and I think this can hopefully give us, at least now it's intuitive to policymakers, that there is something that's more pervasive, and they have similar language in the Digital Services Act in the EU. So I'm glad, at least in the EU context, they're starting to grapple with this terminology, and that can be something we can try and build upon.
Yes, thank you so much. Yeah, again, I completely agree. And I'm so looking forward to your next publications and next contributions from the Institute, because, yeah, I think that yeah, it's really needed right now. So thank you for that.
Thank you so much.
Connor, do you have maybe 5 or more 10 minutes for us to? Okay. So before jumping on the questions I have, I would like to pose a question from the audience. There is one here that I have research interest myself, which is from Vivo Live. I think that's a pseudonym. Countries in Latin America are starting to discuss regulations, AI regulations, and most of them are perhaps inspired by EU. Do you think this inspiration or the Brussels effect is desirable, or do you think and what do you think it's the main challenge for such?
Very good question. Maybe I'm biased because I live in Brussels, I live in the EU, so I do think that it's, but I do think it's a good thing if people take this as the landmark. I mean, I do think yeah, it's definitely not perfect. It's clearly not perfect. But I do think it's a really solid basis to build upon and to go further in some areas, to go lighter touch in some areas if needs be. But I'm glad there's now a reference point. So yeah, I would definitely be encouraging other jurisdictions like Brazil to at least look and learn and stand upon what the EU's done already. I do think the challenge there, though, to the second part of the question is clearly the fundamental rights angle. Like, this is what other jurisdictions, they have, yeah, different levels of conceiving fundamental rights. So I think that's what other jurisdictions will have to grapple with. Like, do they take this kind of merged thing that the EU did with product safety with fundamental rights considerations? Do you take a rights-based approach, principles-based approach, which is what the US is doing? Yeah, I think that's the part where it might not be as directly easy to map on, but yeah, definitely pro using fundamental rights considerations as much as possible, as much as is feasible in other jurisdictions.
Interesting. A follow-up question on that would be: do you see the EU government or the EU itself trying to, I don't know, expand its AI regulatory policy to other countries in Latin America, for example, in Asia, in Africa, or stuff like that? Do you feel like it's economic policy from the EU?
Yeah, so the main area where I see this manifest is in standards, which I mentioned. So you have ISO, like international standards, and there is, from what I understand, like a sort of a race between jurisdictions to get their standards implemented at international level, because then that becomes the reference point for everyone. So that is the most obvious one where I would see like some sort of desire to, not just the EU, but other jurisdictions to try and get their ideas pushed up to the ISO level. But I do think the EU in general is thinking about how to build these bridges and like, yeah, shape some of the thinking in other jurisdictions. Yeah, but the main one I see manifest is in standards.
Okay, thank you, Connor. Another question from the audience is, and it's linked to something that you just mentioned regarding the, let's say, digital platform concerns on AI. It's because like this general purpose technology, they are, as it seems like each time more concentrated with few companies, and they are sort of working like the gatekeepers of the technology and its development and supply. So do you think, how do you see AI in the future in terms of those who control AI? And do you think governments should fight against like this economic sort of control, or that's not desirable?
Yeah, I can speak more, yeah, on my personal opinion. Rather, we want to work on this topic at the Institute, but we haven't yet. But yeah, we're definitely talking a lot about it, and I think governments should intervene on this. I think left to its own devices, what we will probably see is a handful of 3 to 4 like frontier, what they're calling themselves, but general purpose AI model providers. Because you need so much compute, you need so much talent, you need access to proprietary real-time data. There's only a handful of companies that might get that, like Google, Microsoft, maybe Amazon. So this is the thing, and this is the problem, that you see all the startups getting eaten up now slowly by these big corporations. So OpenAI clearly with Microsoft, Anthropic's taking a lot of money from Google and Amazon. So you can imagine they go a similar direction if they want to stay at the frontier. We've seen Mistral in France. They took investment from Microsoft, even though they were saying they were the independent player. Even just yesterday, this is one that we're now paying a lot of attention to, and I think it's crazy because Mustafa Suleyman had his own company called Inflection AI, who were a new startup to compete, and then Microsoft have hired him and a bunch of his team, and Inflection basically doesn't exist now. So that gets around a lot of these antitrust questions. So yeah, I think you can tell from what I'm saying. I definitely think governments should be paying attention to this, and there is the Digital Markets Act in the EU, which looks at these competitive dynamics. I think it might need to be updated to deal with this specific challenge. Because in my personal opinion, I think we need diversity and control of AI systems, and left to its own devices. I think this is the direction the market would go in.
Perfect. I totally agree, Connor. By the way. So another question that you touched upon, the point you touched upon during your presentation, regards the role of standard setting bodies. And I personally research economic regulatory power from these bodies, and what I wanted to ask you is that the establishment of these substantial rules regarding, for example, accuracy, robustness of AI left to these organizations, if that's a point of weakness from the regulation, because the regulation sees it basically as a technical standard, but as you mentioned, it may have like serious impact in terms of human rights and other substantial rights. So my doubt is, leaving that aside to these organizations, which are populated by private companies and other parties, do you think that's a point of weakness from the EU regulation and AI regulation in general, or that's not an issue?
Yes. No, I definitely think it's a big issue. We published some research on this. So we spoke to a lot of people who are involved in the standard setting, and I'd actually be very interested to read your own research, Leonardo, by the way. We did some research on this, and it's clear that these are very industry dominated. They're technical experts, which makes sense for most product standard setting processes, but AI is unique in this sense, given the rights implications. So that's something that, is a big challenge. I have heard more anecdotally and more recently that the level of engagement from independent experts like academia and civil society in the EU standard setting process on AI there's been more uptake from civil society than normal. So it's still going to be industry dominated, but there's been a conscious effort to have more diverse representation, and let's see how that plays out. The EU is also setting up things like a high level sort of forum on standardization. So they're trying to think about sort of centralized mechanisms where you could streamline input on standards from independent experts. And that's something that we're basically also thinking more and more about. Is there like ways where you can get this input on key questions only, like accuracy, like robustness, acceptable levels of bias or whatever? Because right now you would have to be in the room of every standard setting body in every member state, and civil society and academia can't do that. But if they could input on key questions, that would be one way to streamline some of that.
Okay. Well, do you have any questions, Bruna?
Well, we do, but we have time.
Not really. To be fair, not really. And I know that Connor is in Brussels time. You are in Finland's time, right? So I think maybe 6 hours ahead of Brazil. I don't know, 6 hours.
Yeah,
Okay.
5 hours.
So let's end it here. Maybe leave some room for future dialogue and interaction, Connor. It was really a huge pleasure for us to have you here. It was an honor. We hope we can maybe collab with Ada at some point, and we will be very honored to have anyone from ETA here in Brazil, and you're all invited. And Bruna, thank you very much also for bringing very interesting and insightful questions. And that's it. The event will remain online at our YouTube channel, so anyone who have missed any part can return there and see the whole video. All right?
Thank you so much, Leonardo and Bruna. Yeah, it was really an honor for me as well. And yeah, let's definitely stay in touch. Thank you so much.
Yes, sounds good. Thank you for the invitation, and it was a pleasure.
Bye-bye.
Bye.
Bye-bye.
Bye.